The Shadow Attorney General Mark Dreyfus has called on the Attorney General, George Brandis, to explain the circumstances of the shocking and unlawful access of an Australian journalist's metadata by the Australian Federal Police. On Friday, the AFP Commissioner, Andrew Colvin, announced at a media conference his agency had self-reported a breach of Australian telecommunications laws to the Commonwealth Ombudsman, having failed to obtain a warrant before accessing a journalist's phone records. The breach related to an internal AFP investigation into a disclosure of information. Since 2015, agencies that request access to a journalist's phone or a mail records must obtain a journalist information warrant, which in this case the agency failed to seek. While the circumstances of the AFP's investigation and the identity of the journalist remain unknown at this stage, the breach has drawn swift condemnation from press freedom groups and privacy advocates. Dreyfus issued a statement and said the breach was shocking, taking particular aim at the decision to disclose the breach on a Friday afternoon, 2 days after the AFP reported the breach to the Commonwealth Ombudsman. While it is a good thing that the AFP self-reported the breach, the fact that it happened at all is clearly unacceptable, he said. Brandis and the Justice Minister, Michael Keenan, could not just handball the case to the AFP. Both ministers must explain when were they notified of the breach, and what immediate action did they take. Is there a legitimate reason? The public announcement being made 2 days after the breach was reported to the Ombudsman. The Greens Senator Scott Ludlam, who campaigned strongly against the introduction of mandatory 2-year data retention laws, said the case raised broader questions about the government's scheme of access to telecommunications. The independent Senator Nick Xenophon has also voiced strong concerns about the case, and has said he will take it in Senate estimates.